Hello, everybody. Welcome to the almost weekend. It's a good Friday today. I would like to talk today about all of the types of waivers that there are in immigration law. Okay. There are, let me turn that off here. There are a lot of different types of waivers that are available to people in immigration law. And I've done a lot of different lives and videos on drilling down more specifically what the waivers are and how to do them. But I thought I would give just a generalized overview here of the different kinds of waivers so you get an idea of the types of waivers and the voluminous opportunities that one has, even though they think that they are stuck and cannot do anything to go forward. Okay, so first, just a small immigration update here. Just to be clear on the Biden administrative family unity executive order, you can still prepare and file. But I have a lot of clients that are saying, how long will it take? Well, it's enjoined right now from adjudication from a federal judge, which means the federal judge said, stop ruling on it until we work through all this litigation. But you, the immigration, can continue to keep taking the applications. So there's no reason if you qualify not to do it. Don't wait until it's too late, down the road. There'll be 10,000 people in front of you. All right. So given waivers, just briefly, what is a waiver? Well, in some way or another, you are inadmissible. Okay, whatever you're applying for. You might be applying for the green card. You might be applying for a work permit. You might be applying for asylum. You might be applying for VAWA, whatever it is. There's all different kinds of waivers, and they all require different things, and the burden of proof is different, and the qualifying relatives are different. But if you know they exist, that's a great start. Because I have a lot of people who wait years and years without doing anything. And lo and behold, if they knew about this, they could have started way earlier. Like, for example, somebody gets deported. They wait 11 years. They email them. They go, okay, I've waited 11 years. Can I, come back in the country now? I say, well, you could have done a waiver or permission to re-enter basically the day after you were deported. There's other things that are needed. But all in all, the United States law gives an opportunity for people to be able to essentially say they're sorry for something and allow immigration to let them in under numerous types of circumstances. And it's not a loophole. It's not a way around. It's the law. Okay? If you qualify, you prepare it and you submit it and it's granted, then you get in. Okay. So let's start. So the first waiver that everybody knows about most likely is the criminal waivers. Okay, you commit some crime, makes you inadmissible, and you still want to come in. Okay, we can use the example that you're married to a U.S. citizen and, let's just say you're in France, your U.S. citizen wife is in the U.S., and you can't come in because of some crime you committed in France years and years ago, whatever it is. So, without getting into the specifics here, as long as it's not an aggravated felon, more or less, you can see about applying for a criminal waiver. Now, if you're going to do a tree or a chart, you'd have criminal waiver as one of them, and then you could branch it off. You would say, is the waiver older, or is the crime older than 15 years? Okay, if it is older than 15 years, then the waiver is a lot easier to get. So you're not going to do the same type of waiver, criminal waiver, for a crime that's 15 years or older than one that was committed 5 years ago. Okay? So keep that in mind because everything revolves around the burden of proof. And if you have an opportunity to have the burden of proof getting it approved being less, you should definitely take that, okay? Why would you file a more difficult waiver if you have a crime that qualifies for an easier one, okay? And then there's different types of crimes where you break it down. And like, for example, if you have a possession of marijuana less than 30 grams, that's pretty specific, right? But if you do have a possession of marijuana for less than 30 grams, there's a waiver just for that, okay, just for that crime. It doesn't go into all of the different things that are required for a normal waiver. So that's an opportunity. And that's why sometimes when I'm preparing for a case, if they have like another, possession crime, I'll try to vacate that one or expunge it depending on the situation so that we can get this one which fell under the waiver. And then there's, all different kinds in regards. Now, if it's an aggravated felon, you're not going to qualify for the normal waiver, criminal waiver. Okay? So next, how you've heard about people coming in with fake green cards or fake visas, or they come in with, some other type of thing, or they don't put all of their crimes on a naturalization application, all kinds of ways of getting caught in this. You then, have become inadmissible based upon fraud or misrepresentation. Well, there's waivers specifically for fraud and misrepresentation. Okay. And again, the burden of proof is different. The qualifying relatives are different, but that type of waiver also exists. So, just because you came in the country with a fake green card type thing, or a fake, visitor visa, or an H-1B under someone else's name, and you ultimately, for example, get married to a U.S. citizen, there is no reason at all to think that you're never going to change your status. Because if you qualify for a fraud waiver, you can apply and get it. Now, I've had also people say, well, it's been 10 years since I was deported because of fraud, so therefore I can come back in, right? Well, the answer is no. The deportation bar is over. You don't have to file a permission to re-enter, but the fraud still and always exists. You're always going to need a fraud waiver. Okay, now as an important issue with fraud waivers, sometimes it's arguable whether it's really needed, whether there was actually fraud. Like, for example, somebody comes from, Africa and has their 2 daughters or 3 daughters with them, and they're all very young. And they know if they stay any longer in Africa that the daughters will suffer, FGM. It's female genital mutilation. So the mother's desperate, okay? And she buys a fake visitor visa, for her and the daughters, and then they come in. And later the immigration says, well, you committed fraud upon entry. Well, we may be able to show she didn't intend to commit fraud, that she intended to come to apply for asylum and she was desperate and that's the only way she could do it, but it wasn't an intention to commit fraud. Okay, there might be slicing hairs there, but there's ways of showing that. So sometimes when we do the fraud waiver, the first part of it, I might argue that one's not needed and that you don't need to actually do this. And in fact, only if you, the immigration, agree or disagree with me, then you go on to why the actual fraud waiver is needed. Okay, or sometimes there's no qualifying relative, which means they absolutely cannot get a fraud waiver. And so then we have to really argue there's no need for it if such, an argument exists. Okay, so that's the fraud waiver. Sometimes people have medical conditions, okay, that are contagious, and they become inadmissible based upon that. For example, they have tuberculosis or, some other thing that makes them contagious. And because of that, it might mean that, you're able to do a waiver of the medical condition. Okay. Now, the waiver of the medical condition means that, again, you show the various reasons why you're going to come in and why they should waive it. And even though it might be, contagious and so forth, what precautions you're going to take and how, the safety of everyone around you will be done. Okay? So given that, what needs to be done is the first part, you need to see if someone even needs a medical waiver. Okay? And if someone needs a medical waiver or may not need one, again, the first part of the argument is why one is not needed, why a medical waiver is not needed. And, my firm would, when we do it, we argue the law and the facts and we show all kinds of reasons why. And then we say, well, okay, but if you disagree, then this is what you need to do. Okay? So that's that. And it's a little bit open. Okay? I've had ones in the past where immigration has said because there was mental conditions, emotional conditions, psychiatric conditions that have been diagnosed, that the person is inadmissible. And obviously I disagree with that. And I was able to make sufficient argument why legally they're not entitled to claim that they're inadmissible because of that. Okay. So that's that. Okay. So there are also other types of waivers depending on what you're applying for. And for example, if you're applying for asylum or VAWA, Violence Against Women Act, and you're inadmissible for some reason, then the waivers are available, but they're easier to get. And why? Because under policy, they want to make sure, they being immigration and U.S. laws, that if you're in a position where you might be persecuted if you go to your home country, or you might be abused by a spouse because of VAWA, that you shouldn't have to have the same burden of proof on a waiver for being inadmissible. Okay, that you should be able to get it easier than in other situations. Okay, so even though the same waivers might exist, for example, a criminal waiver and so forth, if you're filing a criminal waiver under an asylum application, it'll be easier. I mean, we're talking the exact same crime would be easier to get waived under an asylum application than it would be if you didn't do asylum. Okay, so there's ways of determining what it is you might be applying for. And then, of course, which I've also done videos on, the non-immigrant waivers. Okay, those don't really break down into whether it's fraud or deportation or inadmissibility or a permanent bar. The non-immigrant waiver is if you happen to be inadmissible and there's no security risk to you, then you're able to waive whatever ground of inadmissibility to come in temporarily for whatever reason. Okay? So there's other types of waivers, but these in general are the biggest ones that you're going to see. Now you can see there's a lot of different ones, a lot of different situations. So if you know someone or you are someone who's inadmissible for some reason, don't just give up. Okay? Especially like if you've been deported. You can do what's called permissions to re-enter to get back in way earlier than the 10 years. Okay, assuming you're deportable for 10 years. No need to wait all that time. Obviously if you submit it the day after you are deported, it's going to be a little difficult to get approved. But legally speaking, you can. Okay? So let me, that's the spiel on, overview of waivers. Let me just see if we have any questions here today. And if so, I'll answer them. So I just scroll back through everything. And then we see, one second. How is everybody doing today? I hope well. Let me just scroll a little more. Okay. So today, I don't see a lot of questions. So let me just make sure here. Sorry, it takes a while to scroll through all this stuff. One second. Okay. And then after I scroll for a while, it auto scrolls down like a bunch. But anyways, I think that'll do it. So I hope everybody has enjoyed the live. And if so, even if you didn't, have a good weekend. And then, if you need a consultation, whatever, just get in contact with me, ask the questions, and we'll go from there. All right? All right, everybody, have a good day.